Hello, you're watching Addleshaw Goddard's Employment Channel news programme on the 16th of February. In today's programme, we look at a recent Supreme Court ruling confirming the test to apply when deciding whether an employee who's based abroad can bring an unfair dismissal claim in the UK. We'll also look at an Employment Appeal Tribunal case commenting on continuity of employment when an employee withdraws his resignation. And finally, an update on two important employment law changes taking effect from the 6th of April. First up, an interesting ruling by the Supreme Court this month reminds employers that an employee based abroad may still be able to bring an unfair dismissal claim here in the UK, provided that there's a stronger connection with Great Britain than with the foreign country where they work. This confirms the outcome in the Duncombe case last summer, which we reported on in full in our news programme on the 28th of July last year. The Duncombe case effectively added an extra limb to the jurisdiction test set out in the leading case of Lawson and Serco, and confirmed that the place of employment will not always be the deciding factor when considering whether an employee can bring an unfair dismissal claim in the UK. It will be a question of fact and degree to be considered on a case-by-case basis. In this case, Mr Ravat worked on a rotational basis, 1 month in Libya and 1 month in the UK, which he considered to be his home. Although his employment didn't fall within any of the three Lawson and Serco categories, which were established by the then House of Lords, the court did find that his claim did fall within the UK tribunal's jurisdiction. The fact that Mr Ravat resided in the UK, his employer paid all travel expenses, and his salary was paid in pounds sterling to a UK bank account were all compelling factors which led the court to believe that he had a stronger connection with Great Britain than with Libya. Brochwicz-Lewinski, an employment law barrister from 9 St John Street Chambers, comments on this case in more detail and what it means for employers.
As was noted by Lord Hope in the Supreme Court, the issue of whether proceedings may be brought in the UK for unfair dismissal of an employee overseas is of increasing significance given the growing number of multinational companies and increased labour mobility. This case doesn't change the basic starting point, which is that people working outside the UK are not usually covered by UK employment law. However, the case does show that the starting principle has important exceptions which employers can't overlook. The real issue in the case boiled down ultimately to whether there was a sufficiently strong connection between the employment in question and the UK and UK law that it was appropriate for UK law to be applied. Another way of putting this was that the employment had a much stronger connection with UK law than any other system of law. That was the approach adopted by Lady Hale in the Duncombe case reported last year. On consideration, the Supreme Court decided in this case that Mr Ravat's employment did fall into this category. As already touched on by Liz in her introduction, there are various reasons for this. Mr Ravat lived in the UK and was treated by the company as what it called an overseas commuter, working on a rotational basis, with 28 days working in Libya, followed by 28 days off in England. All his travel expenses to and from the UK were therefore paid by the company. Another point was that while Mr Ravat reported on a daily basis to a manager in Libya and on compliance and policy issues to an African region finance manager based in Cairo, all other HR matters relating to his contract were dealt with in the UK in Aberdeen. Mr Ravat was paid according to UK terms and conditions. He was paid in sterling into a UK bank account. He accordingly paid UK tax and national insurance. Finally, Mr Ravat was also expressly told by his employer that he would continue to be covered by UK law while abroad. So when he was made redundant, that was following the UK company's redundancy process with consultation meetings in the UK, and he was paid a redundancy payment as per the requirements of UK domestic legislation. So for all of these reasons, Mr Ravat was essentially viewed by the Supreme Court as a UK employee who, although he worked abroad, had sufficiently strong connections with the UK and UK law that the termination of his employment fell to be judged under UK law. The message for employers to take away is that even if your employees work abroad, if there are close links with the UK, they might be covered by UK employment legislation.
Thanks, Stefan. In the next case, Chelmsford College Corporation and Teal, the question for the Employment Appeal Tribunal was whether the employee, Mrs Teal, had sufficient service to bring an unfair dismissal claim. You'll be aware that employees can only bring a claim for ordinary unfair dismissal if they have the necessary period of continuous employment, currently 1 year, although this is increasing to 2 years from the 6th of April for those taking up new jobs on or after that date. At the time of the effective date of termination, for example, the date on which a resignation takes effect. The employee's continuity of employment is broken if there's a gap in the employment relationship of 1 week or more. Mrs Teal's period of continuous employment in this case was not completely clear-cut here, as she had previously resigned over a disagreement relating to the payment of overtime, but she later withdrew her resignation when this was corrected, and the college consented to this withdrawal. Again, Stefan Brochwicz-Lewinski comments on this case and what it means for employers.
This case is a straightforward example of the withdrawal of a resignation. The claimant, a college lecturer, gave written notice of her resignation. However, this was not accepted by her employer, which decided instead to treat it as a grievance. Having dealt with the claimant's grievance and upheld it, the college agreed to the claimant, Miss Teal, withdrawing her resignation and continuing in employment. As has previously been established in case law, clear resignations cannot be unilaterally withdrawn. However, they may be withdrawn with consent. The effect of this is to treat the situation as though resignation was never intended and as though it never happened. The effect of that on this case was that when, a short time later, Miss Teal resigned again, she did have sufficient continuity of employment to bring a claim in the Employment Tribunal. The Employment Appeal Tribunal's decision means that the position of an employee who is permitted to withdraw their resignation is similar to that of a dismissed employee who is subsequently reinstated by their employer. When a dismissed employee is reinstated, their original contract is resurrected and they're treated as if the original dismissal never actually occurred. This is sometimes referred to as the vanishing dismissal. This case established the equivalent in the form of a vanishing resignation. This is certainly something for employers to bear in mind if they're in dispute with an employee who is fast approaching the qualifying length of service to claim for unfair dismissal. It underlines that employers should consider very carefully before agreeing to employees withdrawing their resignations.
Thanks again, Stefan. And finally, a quick update on 2 key employment law changes that are due to take effect in just over 6 weeks' time. The government has this week published 2 draft orders. The first allows employment judges to sit alone for unfair dismissal cases, and the second is the increase in the qualifying period for unfair dismissal claims from 1 to 2 years' service for those taking up new jobs on or after that date. Although the orders are subject to parliamentary approval, we were aware of these changes, of course, and are expecting the changes to take effect from the 6th of April. As mentioned in our news programme on the 19th of January, the unfair dismissal qualifying period changes will not affect those employees whose period of continuous employment begins before the 6th of April. The change to the qualifying period for unfair dismissal was announced last autumn, and it's part of the government's wider-ranging initiative to improve business confidence and boost economic growth. Please take a look at our news programme on the 13th of October last year for a more in-depth discussion as to how this change is expected to affect employers going forward, with comment from Dr Stephen Hardy from 9 St John Street Chambers. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and goodbye.